Welcome to the Faculty of Law, University of Lagos channel. Today's lecture will be on family law and we'll be looking at the topic custody of children. The focus of the lecture would have the following learning outcomes. One, at the end of the lectures, you should be able to explain the meaning of custody of children. You should also be able to state and explain the types of custody that may be granted by the courts. You should be able to explain the legal framework for custody of children in Nigeria, identify the relevant sections of the Matrimonial Causes Act that deal with custody of children. A student should also be able to state the principles for determining custody of children, including the overarching principle of the best interest of the child. You should be able to explain sections of the Matrimonial Causes Act that deal with custody of children and how that section is constructed by the courts in terms of the principles that are used to explain or to award custody of a child in a matrimonial dispute, and then give an understanding of the concept of access and visitation rights. Now let's go to the meaning of custody. We may say that custody is the care, control, and maintenance. In fact, you can say the general responsibility given to a responsible adult by a court towards a child. The issue of custody would ordinarily arise because when a marriage breaks down and you are going to get a separation order or a dissolution order, it will no longer be possible for the child of that marriage or children of that marriage to live with both parents, since these parents are going separate ways. It therefore becomes imperative as a critical ancillary relief to determine what happens to those children or the marriage. The court in Nigeria, of course, is governed by a legal framework that is unique to family law, that we normally describe as a plural legal framework, by which we mean that you have different forms of family systems operating, coexisting with each other, none superior to the other generally. These systems include the statutory or English system, which is essentially governed by the Matrimonial Causes Act when it comes to awarding custody of a child. Then you have the customary law system and you have the Islamic system of marriage. And these systems have their inherent principles regarding who should get custody of a child when the marriage breaks down. We also have the major legislation, the Child Rights Act and the Child Rights Law of states that have provisions on custody. And I must mention at the beginning here that the child rights legislation is an overarching statute that applies to every child in Nigeria, irrespective of the type of marriage that the parents have celebrated. It applies to anything that has to do with a child. I said earlier that today's lecture is essentially about custody of children under the Matrimonial Causes Act. So when I say the Matrimonial Causes Act, then you know that we are talking about the statutory marriage, because the MCA applies only to a statutory marriage, a marriage that is celebrated under the provisions of the Marriage Act of Nigeria. And the types of custody that are generally granted, when we say that it is the care, the control, and the responsibility for the nurturing of a child, for the welfare of a child that the court gives to a responsible adult. It means that you are talking about a child as defined by law, as defined by the MCA, and you're talking about an adult who is given that custody. You can have as types of custody various forms in most jurisdictions. The principal ones are legal custody, where you talk about a decision-making power that the court gives an adult. It is possible, for instance, that in the course of getting a divorce under the Matrimonial Causes Act, you have children of the marriage, and the parties would want to determine who should have custody of these children. The court might decide, for instance, to give legal custody to one of the parties and give physical custody to another. The legal custody would then mean the person that has the decision-making authority over a child, where the child should school, major decisions, health issues, and whatever. So, for instance, a mother may be given physical custody of the child to care for in the home, while the father may be given the legal custody, or the other way around. Physical custody relates to the physical control of the child and care for the child. So if the child is given to the father to live with, for instance, that father has physical custody of the child. The same father may be given legal custody, the power to make decision. These kinds of custodies, physical or legal, may be sole, in which case it's given to one person, or maybe joint. That is, sometimes it's split. It may say, okay, the legal custody should go to the mother, while the physical custody may go to the father. One thing about physical custody is that at a point in time, even when it is joint physical custody, the child can only live with one person at a time, as long as those parents are not living together again. That child can only live with one parent. So if the physical custody is given as a joint custody, that means that they may have to share the time the child is living with parents, the mother or the father. Then you can have sole custody, sole legal custody, and sole physical custody, where the court may determine that this child should really live with either the father or the mother exclusively, and should also have legal custody. So that means that in that context, the court might decide to give access or visitation rights to the other parents. Whatever the mode, it will be clear to us that the rules of custody can be adapted to the needs of each relationship, each family, each child. There is no one cap fits all procedure in that respect. The custody under the Matrimonial Causes Act is governed by Part 4 of the Matrimonial Causes Act. And for you to determine the rules of custody, first you must look at Section 69, which identifies the children that can be beneficiaries of a custodial order, the children of the marriage. The phrase children of marriage should be copiously used when you're answering a question in this area. The children of the marriage, as defined under Section 69. So a good student should master the provisions of Section 69, which talks about number one, the marriage must be a statutory marriage and excludes marriage under customary law and under Islamic law. And also that children of the marriage would mean children of either party, maybe born before the marriage, and living with them as a member of their household, or children of the husband and the wife that they had during the marriage, or children that they have adopted since the marriage, or one of them has adopted with the consent of the other. So you need to master the provisions of Section 69. So if you identify that child is the child of the marriage, then you can apply as an ancillary relief, a relief that is adjunct to the matrimonial relief of dissolution or separation for custody of that child. And it also talks about the age of the child, the MCA. So if the child is over 21, for instance, that child, unless there are special circumstances, will not be a beneficiary of a custodial order if at the time they are making the order. This custody can be granted to either parents or to any other person. Sometimes it is even possible the court may decide that the parents are not suitable to have custody, and the court might decide to give custody to another parent, to another adult. Now, the rules that we are talking about in this presentation relate essentially to the Matrimonial Causes Act. That means that the parties are applying for, their marriage is governed by the statutes. The Child Rights Act, like I said earlier, may also be applied even in contexts where you do not have marriage at all, or if the parties are not married, or the child is not a child of a statutory or a product of statutory marriage. These considerations will be taken in subsequent presentations. So with regards to that definition and age of age, and issues of who should get custody, types of custody, you see generally the cases of OT and OT, Ngusu and Ngusu, for further elucidation of these principles. Now, Section 71 is apart from 69, which defines the children of the marriage. Section 71 is quite critical for understanding of the issue of custody, which says that in proceedings concerning the custody, guardianship, welfare, advancement or education of children of a marriage, the court shall regard the interest of those children as the paramount consideration. Now, and subject thereto, the court may make such order in respect of these matters as it thinks fit or as it thinks proper. This portrays the fact that custody is granted on application to the court. Custody, in fact, the court in the matrimonial cause will not make its decree absolute until it's satisfied that proper arrangements have been made for children of the marriage. Okay, so this is a very important consideration before the courts. Children are very important to the law. The court, this order is exercised as a discretion of the court, but in exercising it, the court is governed by this core principle that the interest of the child is of paramount consideration. No longer is it an is no longer we are no longer in the era where issues of children are parental rights, where people can say in a patriarchal society, for instance, it was considered that children belong to their fathers. And in those societies and in those times, when it comes to children, automatically children went to their father. But the principles introduced by the Matrimonial Causes Act and English recent developments of the law recognize the fact that children are, their children are not property that could be just allocated to anybody, and that in getting custody, you must give regard to the interest of the child. Now, over the yes, courts have specified the fact that apart from the children of the marriage, you look at the age of that marriage at the time the court is about to make the order. How old is the child? You may see the case of Omonuju and Omonuju in that respect. The best interest principle that is mentioned in section 71 is a guidance principle. Is a principle that you will now have to apply in practical terms. It's supposed to be what governs your decision. It's what you look at like a lens in whatever I'm doing. That is it really in the best interest of the child? Now we know that really in practical terms, nobody can be absolutely sure whether these decisions can be in the best interest of the child, giving the child to the father or giving the child to the mother in the long run. But the court is just in its, the best that the court can do is to just look at the circumstances before it at the time it's making it in the light of contemporary knowledge and understanding of human relations, and determine if it thinks that this will be in the best interest of the child. So you just look at that principle. If you're answering a question of custody, you must remember that overarching principle and state it. Now let's look at the exercise of the court's discretion in custody matters. When the court is about to exercise its discretion, over the years, some factors have been developed by the courts to guide it to arrive at the best interest of the child. In this respect, please see the cases of Alabi and Alabi and Uduche and Uduche, which give you a very good illustration of some of the things that could happen in practice. One of the factors that the court will use is number one, the age of the child. And in terms of the age of the child, we can say the age, the education, the arrangements made for accommodation of the child, the conduct of the parties to the marriage, the degree of familiarity of the child with a particular parent, the resources that the income the parents have, and the fact that one parent is living with a third party. Let's take the age. Over the years, historically, there is always what they call a tender age presumption in favor of children going to their mother. That is, there used to be a presumption that children of tender age, babies, toddlers, should go to their mother, because it is believed psychologically that at that age, a child needs a mother more than a father. And you can see the case of Udushote and Udushote. This tender age presumption has always been considered as rebuttable. Yes, for instance, let's take a child of 2 and parents are separating. That presumption would work to say, okay, this child of 2 should really go to a woman. It should not go to a man. But it is rebuttable. If there is evidence, for instance, that the woman is of bad character, does not care for the child, and there are some factors that weigh against her, the court will not give custody to that woman. And if the court feels that this custody should not go to a man because this child is practically a baby, they may even give the custody to a third party, maybe a grandparent or someone that they feel can be responsible for the child. So the age works in favor of giving the child, male or female, to the mother, but it is a rebuttable presumption. Then the courts tend to look at adolescent boys and girls. When the child is in adolescent age, a girl child, for instance, there is that tendency over the years to give the custody to the mother, because the courts, I mean, and even evident, lived experience demonstrate that, okay, maybe a girl of 11, 12 would need some maternal guidance about maybe development of the body, reproductive system, and what have you. So that tendency is there to say, oh, this child at this age, this girl should go to the mother. Other considerations being on ground, other factors being in our favor, and that a boy of the same age should be formed by a relationship with a man. So that tendency is always there. But like I keep saying, there's no one cap fits all, and the facts of each case will determine where we should take the child. Then there is also this consideration that as much as possible, we should not separate children. So, like, assuming a family has 3 children, maybe 2 boys and a girl. In this context, the court would prefer if that all the 3 children should ordinarily stay with one parent, maybe grant physical custody to the father or to the mother, and then let them share legal custody, that is, the decision-making powers. So, because of the need to ensure that these children are well bonded, the fact that parents are separating does not mean you should scatter the family entirely. So, to make sure that they bond, and you can only bond by living together, by growing up together, courts also look at that factor and say, okay, let us ensure that as much as possible, let's keep these children together. If you look at these factors, you may now say, okay, if there are 2 boys and the girl is a baby, are you going to keep them together? No factor overrides the other. It's that you now look at them and look at all the factors and see how it's where you arrive. Okay, so this child, there are 3 children. The first 2 are 10 and 12, and then they have a 2-year-old. Should we give the 2 boys to their father and let the mother keep the baby? Or is it not better to keep these 3 children together, let them grow together so that they can know each other, will not be strangers? So these considerations will weigh in the mind of the court. Then sometimes you might see the case of Anyanso and Anyaso in this respect, which shows that the circumstances of each case will determine who gets the custody. You have the wishes of the child. Sometimes when the child is grown up enough, old enough to express a wish, the judge might decide to call the child in and ask the child some questions about who he or she would prefer to go with. And it's not absolute that once the child says, I want to go with my dad or I want to go with my mom, that the court must accept. No, the court, of course, will try to look at the reasons for that and look at it whether it's in the interest of the child as well. But the opinion and the wishes of the child is one of the fundamental principles regarding issues of children and their welfare. The case of Buanhot and Buanhot can assist us in understanding that better. The courts would look at the arrangements for proper care of the child. Which parent has made better arrangements in terms of maybe schooling, accommodation, development? These are things that the court will look at. It's possible that both parents would have made equal arrangements for the child. The mother has resources to get her a good school. The father has the resources to give her equally good school, equally good accommodation. Everything seems to be on a equal basis. In that context, the court will now look at the other factors to determine beyond the arrangement who should get custody. Okay, you both have those resources to give the child the same kind of life that would be beneficial to the child. But if, for instance, you can see that, and there have been a case where the court said that a man that has about 11 children from 6 women, and these children, and even the 1 or 2 of them has gotten married, gotten pregnant as teenage child, is not a fit parent to be giving custody of the child. So even though he has the resources and everything to give the child a good life, that his moral character is in question and may negatively impact the child. So the courts will look at that, and that gives us about arrangement. So you look at the case of Odogu and Odogu in that regard. The monetary consideration is not to be the sole factor. It's not good to say that, for instance, if a man is able to afford a school in London for the child to go to and give the best education in life, the best living conditions in life, and the woman can only afford to educate the child in Nigeria, equally reasonably good school, simple accommodation, the court will not say because the father's arrangement seems to be more buoyant that they will give the child to the father. In fact, it was a disadvantage to a parent in one of the cases where he had brought evidence to show how he would take a child, primary school child, to a boarding house in London. And the court was not disposed to that this is a Nigerian child. Why should that child at that age be disaculturized to go to and live in a foreign land and learn and imbibe a foreign culture? So therefore, it is not that monetary values will override every other thing. Apart from the fact that you have the monetary resources to give a child a good and comfortable lifestyle, because we still look at it whether that will still be in the interest of the child in the light of the other factors. So finally, the conduct of the parties would also weigh in the mind of the judge. The conduct during the marriage is important. For instance, the court might look at the relationship of the child. How does a particular party behave towards the child? Is the child a responsible parent? Now, I must sound a note of warning that custody is never given as a reward for good behavior or as a punishment for bad behavior. That's not what this principle is about. But the court tries to look at the implications that your bad conduct may have on the child, because we are talking about the best interest of the child as being paramount. So we are not trying to reward somebody or or punish the other person. The conduct must impact. In fact, there have been cases where it's been held that a person can be a bad parent, a bad husband or a bad wife, and be a fantastic parent. You can be a fantastic parent, very caring, very loving, very responsible, and still not be a good husband and a good wife. In fact, I had some people tell me and say, oh, they could have their fathers as fathers for their children, but they will not have their father as a type of husband, so to say. So therefore, it's not that the court is trying to punish anybody for the way they behave towards their spouse or whatever, but rather, is there any behavior or conduct in this parent that could negatively impact the child's development? Like the example I gave earlier, if a man that has 11 children from 6 people, and some of them are already pregnant as teenagers, so the court felt that one would not be able to take care of the child. One of the things I will also sound as a note of warning is that in awarding custody, the court, as much as possible, is not to be guided by patriarchal considerations, which were in existence before the Matrimonial Causes Act. What do I mean? Earlier I noted the fact that most culturally, both in African culture and even in English culture, husbands or fathers were regarded as the sole, almost like having a proprietary right to the children of the marriage, because with the status of women as not as inferior, having inferior legal status in law. So these considerations are no longer tenable in a system that thrives on the rights of the child, on equality and in best interest of the child's principle. So you cannot use cultural factors to say, oh, in traditional African society or in the culture of the couple, children belong to their father and women do not have a right to custody. Those considerations should not come in under the Matrimonial Causes Act. In summary, therefore, and I will note that these custodial orders could be varied if a party applies to the court. If you are looking at the Matrimonial Causes Act 772, you also read it together with other sections of Part 4, 73, 74, 75, and what have you, to see the provisions that they have regarding court award of ancillary reliefs and the one that relates to custody of children. So you could always come back and have the order varied or reviewed. The conclusion with respect to this is that the Matrimonial Causes Act has a legal framework for custody of children of statutory marriages. These children must be children of the marriage. They must be of the requisite age as applied by. You can't make a custody order for an adult child. And the central thrust of the custody regime is that you must look at the best interest of the child as a paramount consideration. The award is at the discretion of the court, and in exercising its discretion, some factors will be brought in to assist the court in making a tenable order. Thank you for listening, and I'll see you at the next presentation, where we'll be talking about custody of Islamic marriages and customary law marriages.